Mr. Willis?
May it please the court, I want to first of all thank you very much for the honor of being here today and the honor of representing Mr. Michael Jones in this case. We are here today to begin with to address two questions that this court presented. The first question was, did the Court of Appeals err in upholding the trial court's denial of Jones' request for a subpoena? And the court specifically cited to Yeary versus the state in the question. The request for the source code and the denial of it followed the language from the Court of Appeals in the Yeary case. In other words, the Court of Appeals did exactly what they did in the Yeary case that this honorable court overturned on June 20th of last year in a written decision where the court held that it is appropriate to send a subpoena or request a subpoena to be served upon a corporation, and we do not need to name a natural person. Justice Benham, of course, authored that opinion, citing to Jones' case in Georgia and the Wilson case out of the United States Supreme Court. And the question is answered in the affirmative today, in that the Court of Appeals did err in denying the request for the subpoena due to the fact that we did not name a natural person to be served with the subpoena. The other issue in this case is that based on the actual decision in the Yeary case by our Court of Appeals, I submitted to the Coweta State Court 4 names of individuals that did work at CMI and were agents for CMI to be served with that subpoena prior to the actual trial date of this case. And we did ask for what in my opinion is a plain request under the definition under the Black's Law Dictionary for source code, which is, according to Black's Law Dictionary, the non-machine language used by a computer programmer to create a program. We go on and look at Webster's Dictionary that a program is a sequence of coded instructions. So the request for the source code is simply a request for the set of instructions that were used to calculate the appellant's blood alcohol concentration or breath alcohol concentration. And in this particular case, the court denied it for the procedural reasons exactly as was done in Yeary, and I certainly believe that the trial court erred in doing so.
Now, we also said in Davenport the Court of Appeals was wrong in saying it has to be material and necessary, but we said the statute still requires you to show that what you're trying to seek out of state is material. What evidence did you submit in the trial court that shows that the source code would be material to the particular issues in your case?
Your Honor, I did not submit evidence as it related to that. What I did was I submitted assertions in my motions. And if you look at the case law in Georgia, such as Moffness, French, and Wolleson, all 3 of those cases were based on either assertions made by trial counsel, and that would be the French case, and that would be the Moffness case. And in the Wolleson case, which was cited, of course, in the Yeary decision, in that case, they submitted affidavits to the court in order to support their need for the source code. So not only do I believe that the plain language of the request would be sufficient in this case, and that's based on the fact that we know a computer, the Intoxilogic 5000, computed the breath alcohol results of the appellant. And of course, Justice Namias, you wrote the concurring opinion in the Davenport talking about the fact that the person analyzing that is not there for cross-examination, that the machine is actually performing those calculations. So we certainly know that the machine is performing the calculations pursuant to a code that was given to it by the human beings, of course, the engineers at CMI.
But in that case, they actually had an expert witness who had presented some evidence in the trial court. It seems by the logic you're saying, you know, your brain does all kinds of stuff too, and you could ask for any out-of-state witness saying, you know, I don't know what happens in that person's brain, so I get to go get somebody from out of state. I mean, yeah. And the cases you cited where we relied on assertions, we typically said, even assuming those assertions were true, the plaintiff lost, or the party seeking the information lost. So I don't see how those help you.
Well, in Moffness, the assertion was that a private investigator had been approached by police officers, and the defense in Moffness was entrapment. So they simply said that since that private investigator had nothing to do with the case against Moffness himself, that therefore was not a sufficient showing. And if you think about every case, Your Honor, where there's a witness is not present in court, the state must make a showing of materiality. And how does the state do that in every single case? By a proffer, by an assertion. Because the problem with getting a witness in from out of state is that you need that witness to give you direct evidence as it relates to that. Now, I agree with the court. I could have called experts, and we had the ability to do that in this case, and we did not do that. The record could have been made better. There's no question about that. But I certainly believe that assertions are the way that we deal with out-of-state witnesses and other witnesses that are unavailable every day.
Well, again, there's a difference between an assertion in a motion or just a statement in a motion. I assume it was unverified. It wasn't an affidavit of any kind.
That is correct, Your Honor.
There's a difference between that and a proffer in court where you stand up and say, I have the witness, or I can bring in the witness if opposing counsel wants it, and opposing counsel says, never mind, and the court says, okay. Just saying something in a motion isn't normally considered evidence of any kind.
I understand, Your Honor, but it is plain language that we're asking for, and that was in the motion about what the source code meant, and exactly the same as what Black's Law Dictionary defines it as, which as the programming of the code to determine how the computer operates.
Mr. Willis, let me ask you this. Give me your two best authorities. I was on the dissent.
I understand.
In the case, and I, not to say I was clairvoyant, but thought these things may arise. But could you just give us what you would say you believe controls this case? Do you have a specific case, a specific couple of cases that you say simply are controlling?
Well, I think the plain language, Your Honor, is the controlling aspect of it, and I think that the assertions made in Wollaston, in Moffness, and French are all dealing with out-of-state witnesses under the Uniform Act, and all of those assertions were addressed by the courts, the appellate courts, and determined that well, they basically addressed all of the assertions made by the attorneys, and I think those cases do control this particular issue.
And you think Yeary is controlling too, right?
Well, Yeary, of course, is controlling that that shows that the Court of Appeals erred in its holding, in that the Court of Appeals held exactly as in Yeary that a natural person must be identified and called to testify. And as it relates to the source code, there's also a federal case, which is U.S. versus DeGardi, that has wonderful language in it that talks about, we fully agree that the defendants were entitled to know what operations the computer had been instructed to perform and to have precise instruction that had been given. It is quite incomprehensible that the prosecution should tender a witness to state the results of a computer's operations without having the program available for defense scrutiny and use on cross-examination if desired. We place the government on the clearest possible notice of its obligation to do this, and also of the great desirability of making the program and other materials needed for cross-examination of computer witnesses, such as flow charts, used in the preparation of programs available to the defense a reasonable time before trial. And the reason I quote that case is because that's a 1970 case. That's many years ago, before our true understanding of computers that we have today. It is also very eloquently put. It'd be hard to explain it any better than what the court did in that case, where there was the court held that the programming of the computer is relevant and should be turned over to the defense prior to trial. And I would ask the court to hold that the Court of Appeals did err in this case and follow Yeary and reverse the trial court in regards to that particular holding. In regards to the second question, it is, did the Court of Appeals err in holding that the trial court was authorized to conclude that Jones' encounter with a police trooper at Jones' truck was consensual? I do believe the Court of Appeals erred and the trial court erred in regards to this issue. The language and the requirements for a stop to be, or an encounter to be consensual are far and wide. There are numerous requirements. And the case law requires that in a first-tier consensual encounter, police officers may approach the citizens, ask for identification, and freely question the citizen without any basis or belief that the citizen is involved in criminal activity. As long as the officers do not detain the citizen, that's the first problem we have in this case, or create the impression that the citizen may not leave. That's the second problem in this case. There is no threshold requirement, and indeed the individual may refuse to answer or ignore the request and go on his way if he chooses. go on his way if he chooses is the third problem we have in this case. For this does not amount to any type of restraint. That's the fourth problem. We have restraint in this case, and is not encompassed by the Fourth Amendment, so long as a reasonable person would feel free to disregard the police and go about his business. That's the fifth problem. So this paragraph presents 5 problems for the facts of this particular case, which show that he was not free to go about his business, and this was not a consensual encounter. And in this case, my client was driving behind an SUV approaching a roadblock apparently, which they both learned later was a road check. The SUV turned into a parking lot, as did my client. As the SUV...
Nobody made your client go in the parking lot, right?
That is correct. At that point in time, my understanding is there were no lights. The police had not approached that parking lot at that point in time when my client entered. My client was actually doing a U-turn, getting behind the SUV, and was attempting to leave the parking lot exactly as the SUV was exiting through that same entrance where it came into the lot. And at that point in time, the testimony showed that Trooper McMillan pulled up with his blue lights on and intentionally blocked what he called the only exit to that parking lot at that time, which blocked both the SUV's exit, which was driven by a female, and also blocked the exit from my client, Mr. Jones. My client was in a white truck behind the SUV. And what I think is important in this case is that my client had followed the SUV's exact movements, except for the fact that his maneuver into the parking lot was not abrupt, and there was nothing evasive or illegal about his entry into the parking lot. Besides that, everything else was similar between what my client did and what the SUV did. The trooper then stops, gets out, and approaches the SUV, investigates the SUV for criminal behavior, and based on his testimony, he in fact told her, you can't turn away from a road check once you've committed to it. He then has determined that there is no criminal undertaking by the SUV driver, and then walks back to my client to begin an investigation with him. And the key here is that he walked away from his patrol car rather than back towards his patrol car and just happened to pass my client. So he walks away from his patrol car, walks up to my client's car, and began an investigation with him, asking him what he was doing pulling into the lot. And my question to him that I think is the crux of this case, so before you, and this is a quote, so before you go and walk back to Mr. Jones' vehicle, you had already decided you were letting her out, correct? And her was being the SUV driver. That is correct. And in this case, the court, in this court and the Court of Appeals has ruled many times that a articulable suspicion for the stop, the original investigation must be constrained to that and cannot be expanded. So if at that point in time, the trooper had sufficient articulable suspicion to detain the SUV, and my client was, as a secondary note, ended up getting detained because of that, any detention beyond that first detention, once he had resolved that with the SUV driver and resolved that he was going to let her go, the trooper should have immediately stopped, gone back to his vehicle, and allowed both to exit the parking lot and go along their way.
Was there a second exit?
According to pictures that were submitted to the trial court on the date, and if you look at those pictures, Justice Namias, it looks like an exit a ways down the parking lot. And the key, there are a few keys to that. The first key that I would point out to the court in regards to that is that my client had chosen his path. His path was to exit out of the same entrance he came in. He's not required to change course because of a police officer blocking that course, blocking that exit. He has a right to go out of that exit and could leave through that exit. That's also important.
Well, that's not going to help you much because police officers often stop cars causing a traffic jam, but as long as the cars can get around the stopped car, the police officer hasn't stopped every car, hasn't done a stop of every car in the traffic jam behind the car he pulls over. Or are you saying that the police officer has stopped by official action every car after the car that he pulls over that causes a traffic jam?
Well, Your Honor, the trooper testified over and over again that both cars were trapped inside that parking lot and they were not able to get out of there. So if my client had attempted to leave, I think from the testimony of the trooper, he would have clearly chased him down as trying to elude him based on the fact that he thought and his impression was that he had blocked both of them into the parking lot. That was a trooper's testimony over and over again.
His testimony was that he was trying to block both of them in, or that he was trying to block the first one in, and the second one was also blocked in because there was only one exit?
That is correct. That's exactly the second part. He had intentionally blocked the exit.
For the first one?
That's correct. And that both of the drivers could not exit due to the fact that he blocked the exit. That's right.
Didn't he approach your client just to inform your client that he was about to let this other one go and they could leave?
I don't, nowhere in the,
I thought there was something in the record to that effect.
I did not see anything in the record that said he was approaching my client to tell him anything. My understanding was he was approaching my client to investigate him and talk to him about why he pulled in the parking lot. In fact, I think his testimony was going to approach him to find out what persuaded him to pull into the parking lot, was his testimony. And that was at the original motion hearing, which is held prior to the date of the trial.
Let me ask you this. If it was a non-consensual stop, why isn't that stop still okay as part of the initial roadblock?
Because Jorgensen held that that any time a driver is normal driving avoids a roadblock, then that incidentally avoids the roadblock. That does not require or allow the officer to stop them. And in Jorgensen, they reversed the court, holding that in that case the stop was valid. And what happened in Jorgensen was a driver approached a roadblock, took a turn before it. The actual officers chased down, stopped the person, and they held that the actual stop in that case was invalid, was the ultimate ruling of the court. And in this case, if my client thought it was an accident, just as the SUV driver stated to the trooper, she thought it was an accident ahead, she was turning around to avoid the accident, then clearly he was incidentally driving, but safely, not doing so in an evasive manner, not doing a maneuver.
But the reason why the officer stopped the first car was to discern what was the purpose for pulling into the parking lot, right?
Well, the testimony of the trooper was that she made an abrupt maneuver into the parking lot.
And the purpose of his stop of her was to discern why she pulled into the parking lot.
That's correct, and discern her abrupt maneuver. That's correct.
And what did he say was his purpose in talking to your client's car?
His purpose was to find out what persuaded him to turn into the parking lot, is what his testimony was in the motion.
Again, my question is, was your client's car free to leave? Having voluntarily entered the parking lot, was there a way, and not being stopped by the police officer who was directing his attention to the other car, was there a second exit like the Court of Appeals says, or was there not a second